Good afternoon and welcome back. I'm Marcus Peter. Joining me as she does every week is our friend Andrea Picciotti-Bayer, legal analyst for EWTN News Director of the Conscience Project. Follow her work, conscience-project.org. We're talking about what the Supreme Court will decide in Landor versus Louisiana Department of Corrections. Andrea, thank you very much for joining us. How are you?
I'm doing great, Marcus. How are you?
I'm very, very well, thank you. And as usual, very glad to reconnect with you. So, this case, it's rather unique and it involves something that's inherently biblical in some sense, the Nazirite vow. Tell us what's going on.
So you're right that it's very unique. It's very interesting. Oftentimes we don't hear about prisoner inmate claims, but this one is a really significant one. And the inmate is a Rastafarian and was in prison in Louisiana State Prison, and prison guards told him when he arrived that he needed to cut his dreadlocks off, which were kind of long. They were described as being knee length, which it's kind of impressive. And he presented that he has a right under the kind of federal law that protects the religious liberty rights of those that are incarcerated by the government, both state and federal government. And at one point, the prison guards, through the legal judgment recognizing his religious liberty, in the trash, handcuffed him to a chair and forcibly shaved his head. Now, fortunately, anyone that's reviewed Landor's lawsuit has said that this is just completely unconscionable behavior, right? There's a federal law that recognizes religious liberty of inmates, and there was no justifiable reason for this, and especially it was one that was contrary to legal ruling. But Landor wanted to sue the individual prison guards for this. He's since been, left that location. He's been released. So sending another notice saying, hey, don't shave his dreadlocks would be kind of an empty enforcement. And instead he wants money damages, both to repair the injury that he suffered, but also to serve as kind of a warning that the religious rights of the incarcerated need to be respected by guards, as well as kind of the prison system itself. And unfortunately, the federal courts have said up until this point that there isn't a private right of action. That's kind of a legal phrase, a private right of action for money damages against individual prison officials under what's called RLUIPA, which is kind of a very hard to say acronym for the Religious Land Use and Institutionalized Persons Act of 2000. The Supreme Court's looking at it, and oral argument, you could hear many of the justices concerned about the issue of notice. Do people working in these facilities know that violating religious rights of inmates will subject them to personal liability? Landor and many religious freedom advocates say it's pretty darn clear that this law is one that they need to abide by. But the state is saying no court has ever recognized this, so it's not clear. And so we've got an issue with either the Supreme Court is going to make it clear, or if they say it's not clear in the law, that's where Congress really needs to step in.
As you rightly brought up, the Institutionalized Persons Act, what does it provide for in terms of stipulations? So I know injunctions will cease future harm, but what about him seeking some kind of recourse to justice for the harm that has been done?
Well, and that's the interesting part, Marcus. It's really good that you raise it. The law itself says available relief. And the question is that clear enough to include monetary damages? It's not with regard to monetary damages against the state, but the state has a constitutional kind of immunity from certain monetary damages. But, the enforcement in this kind of situation, really the only enforcement left for Landor is money damages. And so, again, I wanted to raise the issue of the law itself isn't just carte blanche. You can't make up a religious claim. It needs to be a sincerely held religious belief. And the state can say if there's a compelling government interest and the least restrictive means of furthering that interest is restricting religion, well, then government can restrict religion. So it's not, a complete carte blanche for religious liberty. But in this case, it doesn't even seem like it's raised that level. There isn't a strong enough reason that the state has, even though he's confined and with others, to restrict his religious observance, which it is, and no one's questioning the sincerity of it.
The other issue at play here has to do with the fact that it's very clear that if he doesn't receive, it's damages or nothing at this point, because no matter what's going on with him, no ongoing harm is going to befall him, especially as he continues to be part of the system.
Absolutely. So that's where things like an injunction are effective, right? That's basically a court order telling someone to stop doing something. An injunction is irrelevant here, right? Because there's no opportunity to do anything anymore in Landor's case. And it's tough when we think about damages, especially in the context of prisoners. There's a concern that, hey, there's going to be like a floodgate opening, and everyone in jail is going to be coming up with all sorts of nonsense arguments and making all sorts of claims for damages against the people that are running prisons. That hasn't been the case in a companion law, which is the Religious Freedom Restoration Act. It hasn't been that a million people are now coming to courts and flooding the courts with this. What's also important to note, Marcus, is that in the prison context, and this law is applied to prisoners, there are lots of kind of weeding out requirements. One is called the Prison Litigation Reform Act, and that requires prisoners to file certain things first administratively to make sure that it's a legitimate case, that it goes through in a timely fashion, and basically answering all of the concerns that people might have about frivolousness. So really strong, legitimate cases like Landor's are the ones that are getting before the courts, and he should be able to have some form of relief, especially given the egregious nature of the violation of his religious exercise.
So given the RFRA that you have mentioned in Justice Brett Kavanaugh's statement, does the phrase appropriate relief allow for some kind of monetary damages to be placed against, in this case, the individual officer?
It does when there's a RFRA claim, and that was just a case that was decided not that long ago called Tanzin versus Tanver. And so money damages are allowed under a very similarly worded law, and that's where a lot of religious freedom scholars have said there'd make no sense if two companion statutes had different outcomes for when there's a violation. So that's a very powerful argument. The one thing that I can say, and you know how much I love this Supreme Court, especially many of the conservative justices, is they don't like going beyond what the law provides for. And if there's a reason that they feel that the RLUIPA, the case involving incarcerated prisoners, needs to be more clear, well, then we need to advocate for Congress to make it more clear. And I think that may be how this is going to resolve. The case is likely to be, the decision will likely be handed down. It could be even tomorrow or in the next week or two as the court finishes up its term. So it really does give us a sense that there's a step forward. We're not sure whether it's going to be just one step for relief or there'll need to be a step with regard to the legislature. But it's very interesting, and it does highlight, again, the value of religious freedom in America.
Andrea, as usual, thank you very much for drawing these cases to our attention.
Thanks, Marcus.
My guest has been Andrea Picciotti-Bayer, legal analyst for EWTN News, director of the Conscience Project. And we've been talking about, in this case, Landor versus Louisiana Department of Corrections, a religious freedoms case for an inmate. Stay tuned, I'm Marcus Peter.